Excellences, distingués délégués, je déclare ouvert la 23e session de l'Assemblée de cette partie au statut de Rome de la Cour pénale internationale. C'est un honneur et un privilège pour moi de vous souhaiter à tous la bienvenue à cette session de l'Assemblée. Notre ordre du jour est ambitieux. Nous tiendrons des discussions approfondies sur les sujets fondamentaux de la coopération et de l'examen de la Cour et du système du statut de Rome. Nous examinerons et adopterons le budget pour le prochain exercice financier. Nous procéderons à l'élection de membres d'organes importants, à savoir le comité du budget et des finances, le conseil d'administration du fonds d'affectation spéciale au profit des victimes et la commission consultative pour examen des candidatures au poste de juge. Nous adopterons également une décision concernant un nouvel examen des amendements relatifs aux crimes d'agression. Je suis convaincue que l'Assemblée accomplira tous ses devoirs de manière responsable et en temps voulu. Avant de continuer, je vous invite à vous lever et à observer une minute de silence consacrée à la prière ou à la méditation, notamment pour les victimes. Je vous remercie. Before turning to the substantive issues, I would like to provide you with some practical information. We also have to take some purely procedural decisions to ensure the proper functioning of the Assembly. Following a drawing of lots at the 9th meeting of the Bureau on 4th September 24, in accordance with the decision ICC-ASB/1/decision 4 of 3rd September 2002, the delegation Slovakia will take the first place to my right, with the other delegations following in English alphabetical order. Due to the limited capacity of the room, each state party will be allocated 2 seats. The other delegates from state parties are invited to sit in the reserved seats at the back of the room. For observer states, as well as other observers, participants and guests, in accordance with Rule 92, 93 and 94 of the Rules of Procedure, seats are also reserved at the back of the room. NGOs are invited to take their seats in the gallery. Distinguished delegates, in accordance with Article 112, paragraph 1 of the Rome Statute, states that are not parties to the statute but have signed either the statute of the final act of the Rome's conference may participate as observers in the Assembly. Observer states are allowed to participate in the deliberations of the Assembly but may not participate in taking of decisions. Those states that are not parties to the Rome Statute and that have not signed the final act or the statute do not have observer status. Rule 94 of the Rules of Procedure provides that at the beginning of each session of the Assembly, the President may invite those states to be present during the work of the Assembly, subject to approval from the Assembly. I propose that the Assembly invites the following states which do not have observer status to be present during the Assembly's work: Bhutan, Democratic Republic of Korea, Equatorial Guinea, Eswatini, Lao People's Democratic Republic, Lebanon, Mauritania, Federal States of Micronesia, Myanmar, New Palau, Papua New Guinea, Rwanda, Somalia, South Sudan, Tonga, Turkmenistan, and Tuvalu. May I take it that the Assembly wishes to invite these states to be present during its work? I see no objection. It is so decided. As already mentioned, seating has been reserved for observer states and invited states. Seating has also been reserved for NGOs invited under Rule 93 of the Rules of Procedure. Distinguished delegates, the provisional agenda is contained in document ICC-ASP/23/1, and an annotated agenda is contained in document ICC-ASP/23/1/addition 1. May I take it that it is the wish of the Assembly to adopt the agenda as contained in document ICC-ASP/23/1. I see no objection. The agenda contained in document ICC-ASP/23/1 is adopted. Report of the activities of the Bureau. Excellencies, distinguished delegates, j'ai l'honneur de faire rapport sur les activités menées par le Bureau de l'Assemblée cette année. Dans un souci de gain de temps, je me contenterai de souligner certains aspects contenus dans le rapport complet, et qui sera inclus dans les documents officiels de cette session. Je tiens tout d'abord à exprimer ma gratitude envers les deux vice-présidents de l'Assemblée, l'ambassadeur Michael Imrankanu de Sierra Leone et l'ambassadeur Margareta Kasangana de Pologne, pour leur travail et soutien au Bureau et en tant que coordinateur du groupe de travail de New York et du groupe de travail de La Haye, respectivement. Je souhaite également exprimer ma gratitude pour le soutien apporté par le secrétariat au travail de la présidence, du bureau et de ces groupes de travail, ainsi qu'à tous les titulaires de mandats à New York et à La Haye. Pendant la période intersessionnelle, le bureau a tenu 13 réunions pour aider l'Assemblée dans l'exercice de cette responsabilité en vertu du statut de Rome. The Bureau assigned the mandates decided by the 22nd session of the Assembly to its working groups and appointed facilitators and focal points for 2024. The Bureau deeply appreciates their work during the intersessional period in successfully carrying out the mandates of the Assembly. And later this morning, we will consider the report of the review mechanism, which will conclude its mandate at the end of this session of the Assembly. I wish to commend the review mechanism on its excellent work throughout the past 4 years since its establishment. I thank also the court focal points, the court organs, states parties, civil society, and indeed all other stakeholders for their valuable contributions and support of the review mechanism. During 2024, the Bureau has considered on several occasions the mandate relating to the review of the amendments of the crime of aggression foreseen by the Kampala Review Conference. A focal point on the preparations for the review of the amendments on the crime of aggression, Ms. Elisa de Raas from Belgium was appointed by the Bureau in August in order to gather the views of states parties on the venue, format, dates and duration of the review. On 6 November 2024, the Bureau considered the written report of the focal point. The Bureau agreed that the review should be held at United Nations headquarters in New York from 7th to 9th July 2025 for a period of 3 working days. At its 28th November meeting, the Bureau confirmed that the review would take the format of a special session pursuant to Article 112, paragraph 6 of the Rome Statute. Draft language for the Omnibus resolution requests the President, with the support of the Bureau, to continue the preparations for the review, including practical and organizational issues. In 2024, the Bureau has considered the issue of its composition, taking into account, in particular, equitable geographical distribution and the adequate representation of the principal legal systems of the world, pursuant to the request from the Assembly contained in Resolution ICC-ASP/22/Resolution 3. A written summary of the views expressed on this topic is contained in Appendix 2 to the written version of this report. The Bureau will take up the matter again in 2025 with the benefit of this written summary. In May 2023, the Bureau requested the IOM to conduct an evaluation of the Secretariat of the Assembly, focusing on issues of governance, resources, effectiveness, streamlining of functions, and geographical representation. In June 2024, the head of the IOM submitted to me the report on the evaluation of the Secretariat of the Assembly of States Parties. And in July, the Bureau decided to refer this consideration of Recommendation 3, which recommended redesigning the organizational structure of the Secretariat alongside a functional team formation for consideration within the budget management oversight topic in the Hague working group, given the overlap in substance with the recommendations from the former external auditor, which was already under consideration in that context. In October, Vice President Ambassador Kasagana briefed the Bureau on the ongoing discussions regarding the evaluation report in the Hague Working Group. And at its 28th November meeting, the Bureau agreed to submit the Omnibus Facilitator the draft resolution language on the evaluation, which had been agreed in the working group. On 24 October 24, I issued a statement concerning public reports regarding alleged misconduct by the prosecutor towards a member of his office. And subsequently, on 28 October, the prosecutor requested the head of IOM to open an immediate investigation under the umbrella of the IOM into misconduct allegations and surrounding circumstances relating to the official processes of the court and what appears to be disinformation. And on 6 November, the Bureau was briefed by the head of IOM on the IOM's assessment on the request and its reasons for closing the investigation. The Bureau agreed that the President should explore possibilities for an external investigation of the allegations in consultation with the Vice Presidents and keep the Bureau informed. And on 11 November, I issued a further public statement indicating that I'm seeking, on behalf of the Assembly Presidency, an external investigation into the matters related to the alleged misconduct by the prosecutor. An external investigation is being pursued in order to ensure a fully independent, impartial and fair process in conformity with the legal framework of the ICC and the IOM and following a victim-centered approach. And I must insist on due respect for the privacy and the rights of all involved parties, as well as the confidentiality of the investigations. Further information can only be shared once the investigation has been concluded. Another important area of work for the Bureau in 2024 was the recruitment process for the two officials of the Assembly, namely the IOM and the Director of the Secretariat of the Assembly. In both cases, the Bureau had adopted terms of reference which established recruitment panels to assist the Bureau with the recruitment. In July 24, the Bureau decided to adopt the recommendations contained in the confidential report of the recruitment panel for the head of the IOM, which had been submitted to the Bureau pursuant to the terms of reference. The new head of the IOM, Mr. Sylvain Sana de Burkina Faso, takes up the position today, 2nd December. As regards the recruitment of the Director of the Secretariat of the Assembly, the Bureau looks forward to receiving the report of the recruitment panel in the near future. I would like to take this opportunity to formally record my appreciation on behalf of the Bureau and the Assembly to the former Director of the Secretariat, Mr. Renan Villasis, and Head of the IOM, Mr. Saklen Edarali, for their important contributions to the Court and the Rome Statute system. It is the responsibility of the Assembly under Article 112, paragraph 2 of the Rome Statute to consider, pursuant to Article 87 of the Statute, any question relating to non-cooperation. As requested by the Assembly, I have engaged throughout the year with all relevant stakeholders in accordance with the Assembly procedures relating to non-cooperation. On 6 November 24, the Bureau took note of the 24th October 24 finding of the pre-trial Chamber 2 in the situation in Ukraine, ICC-01/22-19. The Bureau also took note of the statement delivered by the requested state party and of its request to leave to appeal to pre-trial Chamber 2, alongside its application for the disqualification of certain judges to the presidency of the court and its urgent request with the appeals chamber. At the 6 November meeting, the Bureau also decided to defer the matter until all proceedings before the court had concluded. And on 29 November 24, I conveyed to the Assembly the decision of pre-trial Chamber 2 on Mongolia's request for leave to appeal, temporary stay of the proceedings and related matters, which was notified to the Presidency of the Assembly in accordance with Regulation 31 of the Regulations of the Court. The protection of the court, its officials and those cooperating with it remains a top priority for the Presidency and the Bureau. It is essential that the Assembly strives to protect the court from attacks and ensure that it preserves its integrity, impartiality and independence. The strategy adopted by the Bureau on 29 July 2022 for responding to attacks against the court, its officials and those cooperating with it, it was applied to confront attacks faced by the court during the intersessional period in 2024. On 7th May 2024, the Presidency of the Assembly issued a statement in support of the independence and impartiality of the International Criminal Court. I once again reiterate the Presidency's firm commitment to uphold and defend the principles and values enshrined in the Rome Statute and to preserve its integrity undeterred by any threats or measures against the court, its officials and those cooperating with it. I also wish to highlight the statement in support of the court issued by over 93 states parties on 14 July 2024. Further to the guidelines for enhancing the security of participants in the regular sessions of the Assembly of States Parties and its side events, which were adopted by the Bureau on 4th October 2023, I continue to consult with states parties, the court and civil society regarding possible further measures which could be undertaken. I encourage a continued dialogue to further reinforce the guidelines going forward. Universality is essential for the effectiveness and legitimacy of the Rome Statute system. The court is a last resort institution, but it can only contribute to the emerging global system of justice if it indeed has the potential to intervene in all situations equally. Striving for universality is a shared responsibility of both the court and the Assembly, and it is crucial for upholding international justice and accountability. In a world that is becoming increasingly fragmented, each step toward universality enhances the court's ability to act fairly, impartially and effectively, reinforcing a rules-based international order in which every individual is held accountable. In light of this, the Presidency, in consultation with the court, has made continued efforts to enhance universality with the assistance of the ad hoc country focal points, the Netherlands and the Republic of Korea, as well as civil society, in particular parliamentarians for global action. Our sincere gratitude goes to all involved in this important endeavour, as their dedication and commitment are vital to ensuring the Rome Statute system remains robust, inclusive and impactful on the global stage. I wish to take this opportunity to welcome the newest member of the Rome Statute system, Ukraine. Ukraine's decision to deposit its instrument of ratification of the Rome Statute on 25th October 2024 is a momentous occasion. The statute will enter into force for Ukraine on 1st January 2025, representing a significant development towards universality. And on behalf of the Assembly of the States Parties, I would like to congratulate Ukraine on this important step. As I conclude this oral report of the Bureau, I want to express my deep appreciation once more to the Vice Presidents of the Assembly, Bureau members, facilitators and focal points, and all states parties. My deep appreciation goes also to our invaluable partners in civil society and the committed staff of the court. Their continued efforts, support and engagement are crucial to the success of our shared goals. We have faced a challenging year, and there are more challenges to come. It is essential that we continue to work together with an unwavering commitment to the ideals of justice, accountability and human dignity. Let us remain steadfast in our collective responsibility to support the court and ensure its resilience and success as a cornerstone of global peace and security. May I take it that we wish the Assembly to take note of the oral report of the Bureau? I see no objection. It is so decided. The Assembly has thus concluded its consideration of Agenda Item 8. Distinguished delegates, we turn to Agenda Item 9, Report on the activities of the Court, and the report is contained in document ICC-ASB/23/19. We are honoured to have the President of the Court, the Prosecutor, and the Registrar present today. On behalf of the Assembly, it gives me great pleasure to extend to them a warm welcome and to assure them of the continuing support of the Assembly in the discharge of their respective responsibilities. I will invite the President of the Court and the Prosecutor to address this plenary today, and the Registrar, Mr. Osvaldo Zavala-Gillet, will deliver remarks to the Assembly when we shall take up Agenda Item 15, consideration and adoption of the budget for the 23rd financial year. I shall give first the floor to the President of the Court, Judge Tomoko Akane. You have the floor.
Madam President of the Assembly, Kaukoranta, esteemed delegates, representative of civil society, ladies and gentlemen, I am honored to appear before the Assembly of State Parties. The court and judges, including myself, only speak through their judicial decisions. That said, I appear before you today in a completely different function. I am here to address you as the President of the Court and on the Court's behalf to talk about the extraordinary situation we are in. In March this year, at the outset of our mandate, I, Vice President Aitara, and Vice President Arapini promised to strive for the stability and strength of the court and its ability to deliver justice in an increasingly fair and efficient manner. We committed ourselves to making the court a safe environment where abuse and harassment have no place and everyone has the opportunity to continue to our mandate while realizing personal aspirations. The difficult circumstances that subsequently arose are only strengthening our determination. We all never give up to coercive measures, threats, sabotage, or outrage. The court, which upholds the principle of the rule of law, will continue pursuing justice and defending the dignity of the rights of the victims of atrocities without fear and favor, while ensuring full respect of the highest standards of defense rights. I make this solemn pledge today before you on behalf of all those who work at the court. As atrocities continue to plague the world, the court has become more and more relevant. We are realizing the expectations of the women and men who dreamed of a permanent, independent, and impartial court since the end of the World War. Particularly in the last 2 years, the court's activities have understandably attracted high political attention. The court has been subjected to attacks seeking to undermine its legitimacy and ability to administer justice and realize international law and fundamental rights by coercive measures, threats, pressure, and acts of sabotage. Several elected officials are being severely threatened and are subjected to arrest warrants from a permanent member of the UN Security Council, merely for having faithfully and diligently carried out their judicial mandate per the statutory framework and international law. 2 other warrants have been newly issued, as in the Presidency's recent public statement. The court is being threatened with draconian economic sanction from institutions of another permanent member of the Security Council, as if it was a terrorist organization. These measures would rapidly undermine the court's operations in all situations and cases, and jeopardize its very existence. We firmly reject any attempt to influence the independence and the impartiality of the court. We resolutely dismiss efforts to politicize our function. We have and always will comply only with the law under all circumstances. We find it appalling that certain states and individuals are scandalized when the independent judges issue decisions in line with the evidence and the law. What matters is not pointing finger, but the moon. We would rather expect that all states, first and foremost states parties to the Rome Statute, as well as all persons, would be scandalized that criminal conduct established to the requisite legal standard have been committed. Right now, in every part of the world, millions of innocent people are victims of unimaginable atrocities and persecution, living in misery, violence, fear, and terror. All decisions of the court are crammed with suffering humanity. If you endeavor to read between the lines, you will find endless stories of shattered lives, pain, and crushed hopes of humans just like us, our children, our mothers, fathers, sisters, and brothers. One can agree or disagree with our public decisions, but please look at the moon and not the finger pointed to it. The court is an international judicial body, as it was underlined by a chamber in a recent decision. By exercising jurisdiction over the gravest breaches of the international principles, values, and laws, it performs functions that align with the general interests of the international community as a whole, and therefore the interests of humanity. The statute clearly defines the scope of the court's jurisdiction and the rules of legal process. Within those boundaries, judges act independently and impartially. Madam President, the staff of the court is our wealth. 1,000 persons from 109 different countries with diverse backgrounds work at the court. Their intelligence, dedication, and passion for humanity, which has been further strengthened in the current extraordinary circumstances, is for me a reason of heartwarming pride. As a new generation of talented professionals is emerging at the court, I look at the future of the of this noble institution with firm confidence. Improving workplace culture is a top priority for the judiciary. This presidency adopts a zero-tolerance policy for any form of harassment and misconduct. Any allegations against judges have been taken extremely seriously and appropriately dealt with under the relevant legal framework. As with all judges of the court, in my judicial functions, I have been listening to the voices of witnesses and victims. I cannot forget what the victim responded when asked why she chose to testify. She stated, "I'm hoping that justice will be administered. Why did they spoil my life like this? Why did they ruin my children's lives? I want justice to be done." This is, I believe, the most profound meaning of our work, to give suffering humanity hope and truth. Madam President, I would like to wholeheartedly thank the presidency of this assembly, yourself, Vice President Kasangana, and Vice President Kanu, all state parties, and all the entities, first and foremost civil society representatives, which have been lending encouragement and support to the court in these difficult circumstances. I will reiterate once again that without states' unconditional support and cooperation, the court cannot operate. Let me be very clear. This is not our court, although technically it is grounded on a treaty. It is also not merely your court. It is the court of your people and humanity as a whole. When you support the court and the cause of international criminal justice, you are supporting yourselves, the value on which your democracies were elected and stand, as well as the principles that tie your citizens together. I have mentioned the existential threat of sanctions. Let me be honest. There isn't such a thing as selective sanctions or coercive measures. If the court collapses, this will inevitably imply the collapse of all situations and cases. Witnesses who the court vowed to protect will be abandoned. Field offices will no longer be maintained. Victims across situations will be left without remedies or hope. Elected and non-elected officials, your own citizens, and their families will endure tremendous consequences. The fall of the court will imply the fall of the rule of law in the international community and a final defeat of the fight against impunity. Victims would no longer be able to obtain justice. For many of them, a world without the ICC is inconceivable. I starkly remember the testimony of a witness who explained why she chose to testify by stating, "I know no one else can defend me, only justice, judges. They are the only ones who can help me. Because what happened to me, I wouldn't want that to happen to anyone else." By bringing down the court, we would be failing these victims and breaking the promise of never again. Madam President, the court needs a stable budget to effectively pass its mandate and address the current challenges. Without adequate resources, the court will not be able to conduct its proceedings at pretrial, trial, and appeals levels, and to deal with those threats and interferences that have become a daily occurrence. In the actual proposed program budget, the court has sought to transparently and honestly explain the actual judicial needs. The unprecedented situation the court faces has brought a transformative shift in the court's security posture. The court has undertaken significant international efforts to strengthen its security in close collaboration with external partners and certain states. The court is particularly grateful to the host state, the Netherlands, for its strengthened political and material assistance. Their commitment to the court and the cause of international justice is admirable. However, we have transparently and respectfully communicated on several occasions that we consider the current security safeguards for certain officials and the court insufficient. We respectfully call for preventative security measures to be substantially enhanced on an urgent basis. The safety and serenity of those officials who carry the burden and the responsibility of difficult decisions is a precondition of the very existence of the court, its independence and impartiality. At the same time, we stress that the burden to protect the court, particularly and politically and physically, must be shared by all state parties. We are gravely concerned that any cuts in the resources requested for security purposes would have dangerous repercussions on our ability to ensure secure and consistent operations. More generally, we respectfully but firmly urge states who have yet to pay their contributions for 2024, including my own country, Japan, to fulfill their financial obligations and avoid delays in the future. On our part, we respect your taxpayers and we commit to spend financial resources honestly and transparently. Madam President, we warmly welcome Armenia as a state party to the Rome Statute. We also welcome Ukraine, which has deposited its instrument of ratification in October and will be a state party as of 1st January 2025, bringing the number of state parties to 125 for the first time in the court's history. This amounts to approximately 2/3 of the international community in all regions. The court will continue to promote the universal ratifications and the full implementation of the statute in close partnership with states and civil society organizations with an eye to achieve proportional representation of each region as a condition to increase the strength of the court. We are demonstrating with our independence, impartiality, resilience, and seriousness that it is worth taking active part in the court. The decision to join the ICC is a commitment of an extraordinary significance. It is not an empty pledge. Rather, it gives rise to concrete legal obligations. Under Part 9 of the statute, states are under a legal obligation to cooperate with a court. The obligation to arrest and surrender is one of the main means to give effect to this duty of states and allow the court to achieve its mandate. The number of arrest warrants that are pending execution continues to increase. This is concerning. Certain state parties host on their territory individuals wanted by the court. Others have failed to cooperate with the court. We respectfully but strongly urge state parties to fulfill their statutory obligations in line with the commitments made when signing the Rome Statute. The statute provides means for states for engage with a court when they have concerns related to cooperation. Constructive dialogue between states and the court in this respect is vital. For it to be meaningful, it must be timely and in good faith. It is worth recalling that, according to Article 119 of the statute, any dispute concerning the judicial functions of the court shall be settled by the decision of the court. We expect that state parties respect the prerogative of the court as a judicial institution to interpret the law and that they do this consistently across all the situations. Public calls for this respect of our decisions and legal interpretations risk weakening the court's legitimacy and credibility, and ultimately your own interest that international law is respected and atrocities are prevented and punished. Cooperation is not only relevant in respect of surrender, it is also essential throughout the proceedings, including upon release or interim release of defendants or suspects from the ICC detention center. We are mindful of the serious burden placed on the host state, and we urge state parties to share this responsibility with the Netherlands. Madam President, esteemed delegates, representatives of civil society, ladies and gentlemen, we are at the turning point in history. Regretfully, this is not rhetorical. International law and international justice are under threat. So is the future of humanity. The International Criminal Court will continue to carry out its lawful mandate independently and impartially without giving in to any outside interference. At this very moment, countless innocent civilians are suffering. Conflicts and persecutions are plaguing the world. The court is not the only solution to this. Courts don't make wars, nor do they make peace by itself. This is a responsibility of politics. The court has a judicial mandate to determine whether certain conduct gives rise to individual responsibility for international crimes. We are mindful of the tremendous responsibility that we have to enforce the principles of the Rome Statute and rules of international law, criminalizing grave breaches of fundamental norms of international law, which are essential safeguards to international peace and security and human dignity. But we cannot do this alone. The danger of the court is existential. We need the support of civil society representatives from all regions of the world. We need a robust assembly of state parties committed to defending the independence of the court and primacy of international law and fundamental rights. The court's future is now entirely in your hands. If you commit individually or collectively to keep the pledge you have made in law, the court can continue to provide what for humanity is the most essential sentiment: hope. Thank you very much.
I thank President Akana for your important and very powerful statement. I now invite the prosecutor of the court, Mr. Karim Khan, to address the assembly. You have the floor.
Madam President of the Assembly of State Parties, Vice Presidents, President of the Court, Judge Akani, Vice Presidents, Chair of the Trust Fund for Victims, Mr. Registrar, Deputy Prosecutors, Excellencies, civil society representatives. It's a great honour to be able to address this 23rd session of the Assembly of State Parties. And in fact, listening to the very powerful and deep address by the President of the Court, Judge Akani, there's a lot to ponder. I do hope that we don't just move on to subsequent events. I think there's an awful lot to digest and really take to heart in that very wise speech by the President of the Court. It's clear by any metric, by any benchmark, this Assembly is at a pivotal time. We are facing unprecedented challenges. We see civil society, victims, survivors, humanity at large, I think, have unprecedented expectations. And indeed, as President Akani said at the end, there is also hope. There is also hope that this court that was given birth to by states, by the Assembly of State Parties, can make a difference for so many that feel completely lost, invisible, persecuted, or without shelter. I've said it before, looking at the globe, we do see a pandemic of inhumanity. Look at Ukraine, look at Palestine, look at Darfur, look at so many other parts of the world where the office and the court are trying to vindicate the promise of the Rome Statute. We see seemingly a world in which people feel their lives don't matter. It seems that we are accelerating towards disaster, and that accelerating almost that life doesn't have value equally. And there's really a fundamental question: whether or not the international architecture that's been built in the aftermath of the Shoah, the horrors of the Second World War, can survive this tempest. Whether or not the architecture can give shelter. And international law, the International Criminal Court, is part of that discussion. It's being tested. And history will judge whether or not the promise of the Rome Statute is vindicated in practice in the maelstrom that we see around us. Not only the storm we face, but winds that are perhaps to come. But despite that, really the focus of my remarks today is that we don't have the luxury, nor do we need to give in to despondency and despair. Not out of some naive belief that tomorrow will be better than today, or some willful, stubborn decision to willfully close our eyes against the reality that we see, but because of you. This coalition of actors, all of you, civil society, victims, states, judges, lawyers, from so many parts of the world that have conurbated from the four corners of the world here in The Hague, not only to recommit to giving effect to the international law obligations of the Rome Statute, but a commitment that every human life matters. And you're part of this movement, the movement that spills out beyond the confines of this Congress Center to so many parts of the world. As President Akani said, the ICC is not a silver bullet to solve the maladies of humanity. There are other justice mechanisms that also are extremely important, and we see this burgeoning willingness of civil society, of victims, of states to embrace national processes under the doctrine of universal jurisdiction, an increased appetite to look at regional human rights bodies for allegations of breaches of human rights, a revitalized, energetic International Court of Justice as a principal organ of the United Nations, and yes, this International Criminal Court. And it is not us, elected officials, who are ships that pass in the night. It is not the representatives and the distinguished delegates in this hall now. It's a movement and a demand from humanity around the world, in Latin America, in Asia, in Africa, in the Caribbean, in the Pacific Islands, in Europe, to put the law center stage. And I think that demand, that rising voice of humanity, is something that we need to pause to listen to. And if we listen, we'll see it's deafening, and it is not being silenced, and it is growing stronger. Just 5 days ago, Madam President, I was in the largest refugee camp in the world, in Kutupalong, in Bangladesh. And I said to the men and women and the children that I spoke to, I think a truth that we've all seen in different contexts in this area of law, that sometimes the brightest hope coalesces in the darkest space. Victims that have endured so much, that have fled, have this righteous demand for justice and accountability, the belief that somehow trumps their own experience of having their rights violated. And one child, as I, with my team, were sitting on the floor in Kutupalong, were rather pathetically and powerfully and simply, as only children can do, told us how every morning, as they were getting ready for school with makeshift teachers in a makeshift location, would sing very loudly the anthem of Myanmar, with love for Myanmar, with loyalty for Myanmar, with fidelity for Myanmar, a country that they yearn to go back to, and yet which refuses to recognize them, and an authority that we allege has been responsible for their persecution and their violence. The voice of that child and other children for something so basic, the right to go home, the right to have a future, the right to have education, the right not to have their childhoods, their futures stolen, is something why, an imperative why, you states with civil society's advocacy and support, demanded the creation of this International Criminal Court. And 10 days ago, I was in Libya. And with the team who's done such fantastic work, we were speaking with many victims, mothers who had lost children and husbands, and fathers who had lost children and brothers. And again, one hears, not sugar-coated, one has to listen to the very painful, the very difficult stories of loss, and the expectation that despite every night being difficult, every day being arduous for them, they believe that this assembly of state parties, the court and its organs, will discharge our responsibilities to see them and their suffering, and realize they are as equal under the moon, as President Akhani said, under the sun, under the day and under the night, as any other child and person anywhere in God's good earth. And 10 days ago in Libya, I could also announce an application that the judges had unsealed of 6 warrants for the arrest of individuals from the Al-Qaniyat militia. And that meant so much to these victims. It didn't ameliorate the fact that they had lost a universe when their loved ones were snuffed out, but they did feel seen. And it helps to give power and autonomy, because the fact that the court had moved forward made them believe that justice wasn't a mirage. It was an oasis that hopefully one day they would drink from, and they could conurbate around to assuage the wounds of their heart and their soul that they have suffered. And I think it's only fair to say that as a court, with the leadership of the President of the Court and the judges and the Registrar and his staff and the Office of the Prosecutor and the excellent men and women of the office, the Trust Fund for Victims, demonstrably we can demonstrate, we can show we're not engaged in polemics and fine words, but concrete actions to show that the law has meaning and has relevance, and we're improving. We're not perfect, but we're improving in the quest to make the International Criminal Court more relevant to people that we serve, to the humanity that we are part of. The day after I was in Kutupalong, I went to Dhaka, and we could announce then also the first applications for warrants of arrest that are now before the pre-trial chamber in Asia, or at least in the Myanmar-Bangladesh situation. And the reaction, if I may follow the example of the President, is worth repeating, because it moved me to the core. And it's something, again, I think should resound loudly. One survivor said this, and I quote, "This is not the end, but it is the beginning of our healing. I now feel that our..." Just 3 days after I left Libya and met with those victims in Tahuna, the Libyan authorities successfully arrested a second person that was named in the warrant of arrest issued by the judges of the ICC. That's not enough. We can't pretend warrants are enough or judicial proceedings are enough. But for communities around the world We should not underestimate collectively the importance of being seen and heard, as they feel their own stories, their own accounts, their own sufferings, the pogroms or alleged criminal activity against them is drowned out by other headlines that we see every morning, noon and night when we turn on our television at home or even look at our phone. And this sense of momentum permeates the collective work of the court. In the last year, my office has received a record number of Article 15 communications from civil society and other stakeholders. A 150% increase last year over the year before, which itself was a record high. We have seen in the last 18 months, because of the collective work in the office with civil society, with other partners, the excellent work of the men and women, the support of the registrar in field activities or security in the field, we have collected we have collected in the last 18 months double the amount of evidence than in the previous existence of the ICC. It's a staggering amount. We have collected in the last 18 months more evidence and information than in the previous 20 years of the office's existence. In the last 12 months, we see more states coming forward to refer matters to the court. Only last Friday, a group of states referred the situation of Afghanistan to my office. And we have reinvigorated and reconceptualized complementarity in the policy paper we put out in April of last year, and that's showing tangible results. The engagement with the Democratic Republic of Congo, with the Central African Republic, with Colombia, with Guinea, show the potential of moving forward so that justice can be delivered effectively for victims at home. There are currently 30 outstanding warrants for the arrest of individuals issued by judges of the ICC that are public. 18 of those warrants have been issued in the last 3 years. And of course, that's the public warrants, and more warrants were issued in the last year than ever before in the history of the International Criminal Court. In relation to Afghanistan, and I mentioned the referral that had been recently made by states, I can also confirm that with the excellent work of the team that's been working consistently, we will be announcing applications for arrest warrants in the Afghanistan situation very soon. In my last briefing to the Security Council in Libya situation, I've mentioned to the Security Council that it is our hope and our expectation that by the time of the next report to the Security Council at the beginning of next year, we'll also be able to announce applications for the warrants of arrest of individuals for the period and the allegations since April of last year between the RSF and the Sudanese Armed Forces. Trials, of course, are progressing apace. The case of Al-Hassan has been decided. The trial chamber found that my office proved various charges of war crimes and crimes against humanity beyond reasonable doubt. We are preparing next week for the closing arguments before the trial chamber regarding the case against Mr. Alfred Yakatom and Mr. Patrice Edward Nakasona. The trial is moving effectively in relation to Mr. Saeed Abdul Khani. The closing arguments in the case of Ali Kushaib, Mr. Abdul Rahman, are scheduled to be concluded next week, certainly this month, and that's largely down to the excellent trial management of the trial chamber. Regarding situations that I haven't mentioned, like Burundi or Côte d'Ivoire, Philippines or Venezuela, the teams have been working with focus to accelerate their collection activities with a view to concrete, clearly identified benchmarks and timescales based upon investigating, incriminating, and exonerating evidence equally. And regarding Venezuela, I want to make something very clear that I've repeatedly said. Since I opened the investigation in Venezuela, in Caracas 3 years ago, we have been working with focus and without delay, and also in line with our stated policy to see if complementarity is possible. And we're doing that in all our situations. And when I was in Caracas in April of this year, I also emphasized to the Venezuelan authorities the need to see impetus and real progress. And my office has been following up in relation to that. And after the elections of this year, I insisted in my communications with Venezuela and in public statements the need to protect the rights of civilians, including children, that they must be released if held for political purposes, or anybody that was peacefully protesting. They must let the Office of the High Commissioner for Human Rights in, as had been previously promised to me in writing, and they must more tangibly cooperate with my office. There has been continued engagement, there has been continued discussions on complementarity, but complementarity cannot be a never-ending story. I have not seen the concrete implementation of laws, practices in Venezuela that I had hoped for. And so I want to be clear that the ball is in Venezuela's court. The track of complementarity is running out of road. And as I've said repeatedly in public statements and in Venezuela, that our independent investigations are going on. They've always been in parallel. They are active. And we are partnering, we are working closely with a variety of partners to discharge our responsibilities so that, going back to my first comment, all life matters equally. Venezuelans have the same right to justice as the families I met in Libya or in Bangladesh in the last 2 weeks. This is as basic as it gets, but it's worth underlining that imperative in terms of the decisions that my office is undertaking. Madam President, I hope I've been able to make out a case that in the gloom, in the tempest I referenced, in the uncertainty and perils of this moment, we can face these challenges if we stay united, if we stay together. It starts with commending the fortitude, the indefatigable energy, the resilience of survivors and victims, support of civil societies. The hope is not incapable of being extinguished. It is a fragile hope. It is a hope, to steal a phrase of Elton John, it's a candle in the wind. It can be snuffed out. It's for us collectively to shield that flickering flame, and what will blow it out, I think more quickly than anything, is the idea that we're not applying the law equally in all situations, that all life doesn't matter equally. There is a hierarchy in terms of which people with which passports from which parts of the world are more worthy of protection and which people can be disposed of or be rendered invisible because of power politics or the inconvenience of applying the law with fidelity and with integrity. We need cooperation. We need resources. We need cooperation in terms of executing arrest warrants that are sealed or public. We need solidarity. We need to realize that, like hydrochloric acid, what is extremely corrosive to everything that's been built from the foundations of Nuremberg and all the suffering we've seen in the decades since, and which we see so vividly today, is the perception that it's not a level playing field and that Lady Justice is peeking out from the blind, from her blindfold, to actually see, is the lance of justice going towards a power interest, or is it an area where the law can be applied because there won't be too many inconveniences caused to international relations or power structures? If we work together, I think realistically, there can be hope. But we need to march shoulder to shoulder, victims, survivors, civil society, states. Everybody needs to be a partner in this. Everybody has a role to play. If we raise our voices and steel our spine and fill our hearts with the principle that all lives are of equal value, if that is our belief, if that is our creed, if that is our mantra, and we wed it to collective action, the hope that is so eloquently put forward in the preamble to the Rome Statute may yet strengthen this candle of hope and pierce the darkness of this present age. Thank you so much.
I thank Prosecutor Khan for your informative and very useful statement. I propose that the Assembly take note of the report of the International Criminal Court contained in document ICC-ASB/23/19. I see no objection. It is so decided. I would like to take this opportunity to express my gratitude to the Court for the support it has provided to the review mechanism, to various mandates and initiatives of the Assembly, to the Bureau and working groups, and to me personally. The Assembly has thus concluded its consideration of Agenda Item 9. Distinguished colleagues, let us now turn our attention to Agenda Item 10, report of the Board of Directors of the Trust Fund for Victims. The report on the activities and projects of the Board for the period of 1st July 23 to 30th June 24 is contained in document ICC-ASB/23/4. I now have the honor to give the floor to Ms. Minu Josefina Tavares Mirabal, Chair of the Board of Directors of the Trust Fund for Victims.
Señoras presidentas, señor fiscal, señor secretario, sus excelencias, buenos días. Me honra estar hoy frente a ustedes, la Asamblea de Estados parte del Estatuto de Roma, para presentarles mi última rendición de cuentas sobre el trabajo realizado con mis colegas en el 7º Consejo Directivo del Fondo para las Víctimas de la Corte. Quiero invitarles, en primer lugar, a reflexionar sobre la visión de éxito del trabajo de la CPI que tiene cada Estado parte y la Asamblea en su conjunto. Esta visión debe remontarnos a 1998 en Roma, cuando históricamente y como expresión de un movimiento social y global de décadas se adoptó el Estatuto de Roma que nos gobierna. En el mismo, ustedes decidieron establecer una corte penal única, una corte que pronuncia justicia excepcional y justicia reparadora y transformadora. Desde entonces, dicen muchos, la Corte ha fallado. Solamente 6 casos sentenciados. ¡Qué escándalo! Visitemos sus excelencias cada uno de esos casos. En el más pequeño de estos casos, el caso Katanga, la Corte ha garantizado justicia para 297 víctimas. Hoy, 2 de diciembre, el Fondo de Víctimas presenta precisamente hoy ante la sala de juicios el informe final de las reparaciones dadas a dichas víctimas. 297 no son muchas personas, dicen. Poco han importado esas víctimas a los grandes titulares de los medios. Ellas son, sin embargo, una víctima menos que aquellas que perecieron en el ataque contra el vuelo MH17, que convulsionó al mundo, como deben recordar. El siguiente caso nos lleva a Timbuktu, cuando milicias yihadistas destruyeron los mausoleos, afectando no solo la herencia cultural, la prosperidad de la comunidad, sino a cerca de 2.000 familias que perdieron a sus seres queridos. Este número es cercano al número de víctimas aún buscadas en fosas clandestinas de las víctimas yezidi en Irak. El otro caso nos lleva a Ituri, el caso de Tomás Lubanga, que implica a cerca de 3.000 víctimas, adultos hoy que cuando niños fueron forzados a participar en las milicias como soldados. 3.000 almas son la misma cantidad que los acaecidos en el ataque contra las Torres Gemelas el 11 de septiembre de 2001. Los 2 más recientes casos, el de Ntaganda y el de Ongwen, han sido seminales por su masividad y por las atrocidades de violación, de brutalidad. Centralmente, esos casos son sobre esclavitud sexual de niñas y niños, sobre mutilaciones y tortura infligidas sobre poblaciones civiles y sobre el impacto transgeneracional de estos casos. La población de víctimas de ambos casos juntos llega al menos a 65.000 personas. Ese número es 8 veces las víctimas acaecidas en el genocidio de Srebrenica. Cuando los jueces decidieron que las reparaciones para estos casos tendrían un valor de 31.3 millones de euros y 52 millones respectivamente, los jueces no fueron irresponsables, como algunos han dicho. De hecho, actuaron de manera prudente, dando lo mínimo requerido como acto simbólico, pero material de reconocimiento. Con estas decisiones de reparación, los jueces están haciendo realidad la visión de éxito que en Roma ustedes encomendaron a la Corte Penal Internacional. Una corte activada ya en 17 situaciones alrededor del mundo. Una corte que si bien no puede atender a todas las víctimas, busca y logra con recursos limitados y altos riesgos, a través de la participación del fondo, estar cerca de ellas y por su mandato reparativo les deja algo para el futuro. No existe institución similar como el fondo a nivel internacional. lograr 250 o 750 euros para cada víctima. No es sustentable, es muy costoso, es muy poco, es mucho, se nos dice. Les voy a decir qué puede lograr. Primero, una expresión de solidaridad. Sin ella no hay humanidad. Sin ella no hay futuro. Segundo, salud mental, que está en el centro de las intervenciones del Fondo de las Víctimas, como aprendimos muy bien en la pandemia. Sin ella no hay prosperidad, no hay oportunidad, no hay futuro. Niños crecidos en violencia son un futuro de pobreza y de miseria. Tercero, estas comunidades, estos adultos jóvenes son la esperanza de sus comunidades. Sin ellas, las inversiones económicas buscadas en estos países serían fútiles, ya sea porque estas comunidades no podrán participar en las mismas o porque serán violentadas por futuros grupos armados de aquellas víctimas que dejamos olvidadas en el pasado. Cuarto, la Corte Penal como laboratorio de iniciativas ha inspirado y catalizado a través de sus investigaciones, aún las fallidas, de sus sentencias y de sus órdenes de reparación, la acción de jurisdicciones nacionales alrededor del mundo. Eso es lo que queríamos cuando hablábamos de complementariedad. Las ruedas de la justicia están en movimiento. Gracias a Roma, gracias a ustedes. Excelencias, la justicia y la pacificación que conllevan los juicios y las reparaciones son esenciales para reducir los flujos migratorios. Así es como la CPI está conectada con las preocupaciones de muchos gobiernos aquí representados. Somos hoy vecinos de las deliberaciones ante la Corte Internacional de Justicia. Y hoy, cuando pensamos en retos globales, no pensamos en la CPI, pensamos en el cambio climático. Pero sin Estado de Derecho no habrá soluciones para salvar nuestra madre tierra. Y la CPI es la expresión más alta de ese Estado de Derecho. Y por ello, cuando pensamos en retos globales, la CPI no puede ser dada por sentada. Es por ello que como Consejo Directivo del Fondo expresamos nuestra más alta preocupación por el impacto que tendrán sobre millones de víctimas posibles sanciones contra la Corte. ¿Cuál es el balance entonces del compromiso hacia las víctimas? Desde la primera contribución recibida en 2004, 52 estados partes han contribuido a la Corte. Los restantes 72 no han hecho ninguna contribución en estos años transcurridos. De los países en desarrollo, las contribuciones, aunque apreciadas, son francamente inconsistentes y presentadas en volúmenes escuetos, acotados, que casi parecen suspiros, suaves susurros, afterthoughts, como les dicen. De los países en desarrollo, de nuestro sur en África, América Latina y el Caribe y Asia, las contribuciones, aún simbólicas, salvo un par de excepciones, están completamente ausentes. Silencio total. El séptimo Consejo Directivo ha reflexionado de manera profunda y extensa sobre cómo cambiar esta situación. Ha dialogado, ha hecho preguntas y ha escuchado. Hemos visto que en La Haya las embajadas no tienen acceso a recursos conectados a las áreas de inversión de nuestros programas como educación, violencia sexual, salud mental. cuando ponemos de frente montos conmesurados a las órdenes de reparaciones, hay bloqueos, silencios incómodos, cejas que se elevan. Los montos les parecen ideas ridículas, fuera de la realidad. En las capitales del mundo, que han sido testigos en primera fila de las atrocidades vividas por las víctimas y donde las inversiones en asistencia humanitaria, desarrollo e inversiones económicas y militares son estratosféricas en comparación con nuestras peticiones, hemos escuchado desapego e incredulidad. Y a veces la pregunta, ¿por qué nos toca a nosotros pagar por los crímenes de tal o cual en tal o cual lugar del mundo? No ha sido suficiente lo que ya costó el juicio, lo que hicimos llegar a La Haya o la inconveniencia política que nos trajo. Les repito, por la solidaridad, por el futuro de las víctimas, por inversiones estratégicas de prosperidad, paz y seguridad, vale la pena. Y por el Estado de Derecho. Al final, porque ustedes nos lo encomendaron y ahora debemos estar en capacidad de dar respuesta. Sí. El fondo será creativo y buscará mecanismos alternos, sector privado, personalidades, etcétera. Pero son los estados quienes lo prometieron y quienes olvidaron terminar de construir el camino entre Roma y las políticas y los presupuestos. Son los estados quienes en sus ministerios han puesto a la CPI en portafolios alejados de la realidad que la CPI busca atender. Y hoy es el momento de conectar ideas y áreas de trabajo y hacerlas realidad. Sobre todo, más allá de recaudar 75 millones de euros en 7 años, que son, por cierto, 10 millones por año, que divididos entre 25 cooperantes para el desarrollo, no significan más de 400.000 euros de cada uno de esos cooperantes. Más allá de esta recaudación que creemos factible y necesaria, lo que el Consejo Directivo del Fondo para las Víctimas propone es una alianza con los Estados parte para reanudar el consenso de Roma y completar el efecto transformador que buscábamos. Debemos transformar el sistema y equilibrar las acciones militares con acciones judiciales y las acciones punitivas con las acciones reparadoras. Esa es la propuesta transformadora que en 2025 esperamos podremos emprender juntos, esta Asamblea y la Corte Penal Internacional. La semana pasada tuve la oportunidad enorme de presentar reflexiones similares frente a la Asamblea General de Naciones Unidas en ocasión del 25 aniversario de la adopción de la resolución que denominó el día del asesinato de mi madre y mis tías como Día contra la Violencia hacia la Mujer. Ese lunes cumplí mi sueño de niña de hablar frente a más de 150 países en ese salón dorado y pensé en mis mariposas. La Corte Penal y su fondo de víctimas es una de esas mariposas. Dotada de una ruta ambiciosa, pero con alas débiles, volando en y misiles. Por el futuro del Estado de Derecho, confío que la Asamblea tomará decisiones en esta sesión y en los importantes meses que nos esperan para proteger y reforzar nuestras alas. Ha sido el honor de mi vida, quizás uno de los más grandes, poder servirles como integrante del Consejo Directivo del Fondo. Junto a los miembros salientes, les agradecemos y les dejamos la encomienda de continuar. A los jueces por sus decisiones de principios, gracias. A la presidenta de la Corte, incansable defensora de las víctimas, al secretario, quien ha servido de ilustre asesor del Consejo Directivo, a la Fiscalía, cuya acción ha permitido el éxito en los casos, a la directora ejecutiva y al equipo comprometido del secretariado del Fondo para las Víctimas y a cada una de las personas que trabaja hoy de manera valiente en la Corte Penal Internacional. Permítanme entregarles todo mi reconocimiento. En Bogoro nos recordaban que la justicia es una forma institucionalizada de amor. Amémonos, entonces. Muchas gracias, muchas veces.
I thank you, Tavares Mirabal, for your statement, and on behalf of the Assembly, I would express to you and ask that you convey to the distinguished members of the board the appreciation of the Assembly for your tireless efforts and commitment to provide effective remedy to victims. I propose that the Assembly take note of the report of the Board of Directors of the Trust Fund for Victims contained in document ICC-ASB/23/4. I see no objection. It is so decided. We have thus concluded our consideration of Agenda Item 10. Let us now turn to Agenda Item 11, review of the International Criminal Court and the Rome Statute system. The Assembly has before it the report of the review mechanism submitted pursuant to Resolution ICC-ASB/21/Resolution 4, which is contained in document ICC-ASB/23/14. As you know, Ambassadors Paul van den Eyssel from Netherlands and Michael Canu of Sierra Leone have led the work of the review mechanism in The Hague and in New York. I invite Ambassador van den Eyssel to introduce the report from the rostrum, also on behalf of Ambassador Canu, who is unable to join us today. You have the floor.
Thank you very much, Madam President. Of course, distinguished delegates, friends of from the court, ladies and gentlemen. I was sitting in the back listening to the speeches by yourself, by the President, by the prosecutor, and all of you spoke about external challenges, and rightly so. External challenges are not new to the court, but they're there now perhaps in a more severe form than we've have witnessed so far. And I just wanted to recall that when we started the review, there were also external challenges. And one of the objectives of the review, of course, is to come to a strengthened court and a strengthened ICC system. And I, together with Michael Khan, led that process in strong conviction that a stronger system, a stronger ICC, will help us to survive these and to counter these challenges. And I'm still believing that. It is, of course, an honor to stand here and to introduce the report you mentioned, contained pursuant to Resolution ICC-ASB/22/6, and it's found, as you said, in document ASB/23/14. It follows our first semester progress report, and it gives you an overview of the work completed in the second semester, and it outlines the progress made in response to Resolution ICC-ASB/22/7, adopted by the Assembly in December 2023, which tasked the review mechanism with completing the assessment of all recommendations submitted by the group of independent experts in their final report of 30 September 2020. And I'm pleased to report that all but one, and that one is recommendation 140, of the 384 recommendations have been assessed. Additionally, the Assembly decided to implement a tenure policy at the International Criminal Court, effective as of the 1st January 2025, and to further consider the Court's proposal for its implementation. The Assembly also asked the review mechanism to facilitate this process and report back ahead of its 23rd session. In the last year, in 2024, we primarily focused on this mandate, while also addressing a proposal from the Group of African States for a moratorium on the recruitment of staff from non-state parties. We also held a roundtable on workplace culture on the 30th of September 2024. Workplace culture has been a priority issue from the very start of this process, expressed by the experts, by the Court and by all stakeholders. And we were very pleased to have in our midst at that session Mr. Richard Goldstone, Chair of the Group of Independent Experts. And that Workplace Culture Roundtable gave us valuable insights on the experts' views and, of course, on the views of others on this important issue. In Section 2 of the report, we kept the mandate of the review mechanism as outlined in Resolution ICC ASP 20-3, and the deadline for the completing key stages of the mandate, which included the categorization, the comprehensive action plan, as well as the mandates of ICC ASP 23-7. While many of the discussions on the tenure policy and on the moratorium were held in closed sessions at the request of a state party, we also emphasized that the continued practice of the review mechanism would be to work in transparency and inclusivity. Madam President, the assessment and where appropriate the status of implementation, because of slowly during this last 4 years we go from assessment to implementation, and in many cases implementation has already been completed. That is reflected in the matrix, progress in the assessment of the independent expert review recommendations, a living document that is continuously updated and which will be included in Annex 5 of the report. In Section 3 of our report, we give detailed information on our work on the tenure policy and the moratorium. Discussions on the tenure policy were supported by the Registry Legal Office, which prepared draft amendments to the staff regulation and rules. These discussions resulted in a draft resolution included in Annex 1, which introduces a tenure policy for P5 and director levels, effective as from the 1st of January 2025. The draft also includes key elements such as mobility clause and a provision excluding parental leave from the tenure period. As for the moratorium on the recruitment of staff from non-state parties, first of all, my gratitude to the African Group for their proposals and flexibility. The agreed proposals form the basis of the draft resolution, including in Annex 2, which introduces a moratorium effective as from January 2025. All the three resolutions we have reached ad referendum agreement among all states parties. As I mentioned, Madam Chair, we have held a roundtable on workplace culture, and we see, and I will come to that, this is a topic of ongoing follow-up work. First Monday of the month, this is always happening, so don't be afraid. I think the noise is fading away, so I'll continue. So this is a topic where we foresee ongoing follow-up work, and I'll get back to that. Looking ahead, the draft resolution the review of the International Criminal Court and the Rome Statute identifies 5 key areas that were formerly under review mechanism mandate, but do not fall within any existing facilitation. In this draft resolution, the Assembly would request the Bureau to determine the appropriate forum for overseeing the implementation of these recommendations, or topics actually, including working culture, there it is again, relation with civil society and media, tenure policy, a moratorium on the recruitment from non-state parties, and the trust fund for victims. The resolution also calls for the Bureau, through its working groups, to continue monitoring the implementation of recommendations that have been positively assessed or assessed with modifications. Additionally, it mandates follow-up action from the Assembly, mandate holders, and the Court for the implementation oversight. Finally, the resolution requests the Secretariat to keep the matrix on progress in the assessment of the RI recommendations, which perhaps could be changed then in implementation of the RI recommendations, but I leave that to those who follow us, updated and circulated ahead of each annual session. As we move past the assessment CES, as I said, the matrix will now focus on the implementation, if still appropriate, because many recommendations have been implemented, I think. As I said, on all three resolutions, we have agreed on the referendum agreement. During this ASP, the review mechanism will hold a plenary discussion on Wednesday, December 4th, from 1500 to 1630 hours, titled Review of the International Criminal Court and the Rome Statute System, the conclusion of the review's mechanism mandate, and the future of the review process. And we do invite all stakeholders to attend and share their views, especially on the future of the review process. As the review mechanism concludes its work at this session of the ASP, and we hope that the ASP will terminate our mandate, but there is still work to be done, so we encourage stakeholders to engage in the follow-up work outlined in the resolution. Madam President, I think I've said all on the report, so let me thank also on behalf of Michael Khan, who will join us tomorrow, and the focal points from Bangladesh, Chile and Poland. Our heartfelt thanks to the support and guidance we got from you, Madam Chair, from the ASP Vice Presidents throughout our term. We do very much appreciate and thank the work of the Court focal points, and of course those who started this in a way, the IAR experts, for their invaluable contributions to our discussions. I thank you very much, Madam President.
I thank Ambassador van den Eysel for the introduction of the report. I would also like to thank both him and Ambassador Kanu, as well as the other members of the review mechanism for their tireless efforts in fulfilling their crucial mandate. We shall revert to this agenda item at our plenary meeting on Wednesday afternoon, as was indicated. The Assembly will now begin its consideration of agenda item 5. In accordance with Rule 25 of the Rules of Procedure, a Credentials Committee consisting of representatives of 9 states parties shall be appointed at the beginning of each session on the proposal of the President. After broad consultations with states parties, I propose that the Credentials Committee consist of the following states: Estonia, Japan, Mexico, Netherlands, Panama, and Switzerland. May I take it that the Assembly agrees to proceed accordingly? It is so decided. The Assembly will appoint the remaining 3 members of the committee at a later meeting. I wish to remind representatives that pursuant to Rule 25 of the Rules of Procedure, credentials shall be submitted to the Secretariat, if possible, not later than 24 hours after the opening of the session. Credentials shall be issued by the head of state or government, or by the Minister for Foreign Affairs, or by a person authorized by either of them. Before we move to the next agenda item, I wish to indicate that the Bureau decided to recommend that the Assembly appoint Ambassador Roberto Calzadilla Sarmiento from Bolivia as rapporteur for the 23rd session. Does the Assembly agree to appoint Ambassador Roberto Calzadilla Sarmiento as rapporteur for the 23rd session? I see no objection. It is so decided. Distinguished delegates, we shall now turn to agenda item 6, organization of work. The Bureau has considered the program of work, which is reflected in the ASB journal dated 29th November 24. The Bureau proposes that this program form the basis of our work for this session. I trust that you will all understand that the program of work may be subject to modification depending on the program attained on the different items. I would ask each representative to ensure to arrive on time to the meetings in order for the Assembly to complete its consideration of all the items on the agenda for the 23rd session. May I take it that the Assembly decides to adopt the program of work reflected in the ASB journal dated 29th November 24. I see no objection. It is so decided. As proposed by the Bureau, the Assembly will meet a plenary session and will hold informal consultations on some key issues on which decisions must be taken. At its 4th September 2024 meeting, the Bureau recommended that the following representatives serve as coordinators for the 23rd session. For the working group on the program budget, Ambassador Ana Cristina Rodriguez-Pineda from Guatemala, and for the informal consultations on the omnibus resolution, Ms. Beatrice Maillet from Canada. May I take it that the Assembly wishes to proceed on this basis? I see no objection. It is so decided. I congratulate Ambassador Ana Cristina Rodriguez-Pineda and Ms. Beatrice Maillet and wish them every success as they carry out their responsibilities. I assure them that they can rely on the Bureau to provide any guidance that may be necessary. The Assembly will now turn to agenda item 4, states in arrears. According to Article 112, paragraph 8 of the Rome Statute, a state party which is in arrears in the payment of its financial contributions towards the costs of the court shall have no vote in the Assembly and in the Bureau if the amount of its arrears equals or exceeds the amount of the contributions due from it for the preceding 2 full years. The Assembly may nevertheless permit such a state party to vote in the Assembly and in the Bureau if it is satisfied that the failure to pay its due is due to conditions beyond the control of the state party. The Secretariat sent a note verbal dated 28 October 24 to all concerned states via their United Nations missions as well as their embassies in The Hague and Brussels, informing them that they were in arrears and stating the minimum payment required to avoid the application of Article 112, paragraph 8 of the Rome Statute. In accordance with information provided by the Court, it would appear that Article 112, paragraph 8 of the Rome Statute is currently applicable to 13 states parties. I wish to note that the Bureau, having received requests for a waiver from the loss of voting rights for the 23rd session of the Assembly from Liberia and Venezuela, decided to recommend that the Assembly grant these requests for a waiver from the loss of voting rights at the 23rd session. At the same time, as mentioned in my oral report, the Bureau agreed to take up in 2025 the issue of possible criteria for assessing requests for a waiver of the loss of voting rights pursuant to Article 112, paragraph 8 of the Rome Statute. And I see that the delegation of Argentina wishes to take the floor. I give the floor to the delegate of Argentina.
Gracias, señora presidenta, y buen día a las autoridades de la Corte y al resto de las delegaciones. Siendo esta mi primera intervención, permítame felicitarla por su designación como presidente de esta Asamblea. Quienes tuvimos el privilegio de conocerla y trabajar con usted en otra capacidad, sabemos de su profesionalismo y habilidades diplomáticas, las cuales nos permitirán, sin lugar a duda, una culminación exitosa de nuestros trabajos. Señora Presidente, la Argentina, de modo coherente con la posición que ha venido sosteniendo en relación con la situación en Venezuela, entiende inadmisible que esta Asamblea autorice, en los términos de la última parte del artículo 112.8 del Estatuto de Roma, a los representantes del régimen venezolano a ejercer derecho a voto en este 23 periodo de sesiones. Los motivos son los que ya se han señalado y seguirá señalando la Argentina. Venezuela no puede considerarse un Estado de Derecho. Los derechos humanos y civiles son sistemáticamente vulnerados y la voluntad democrática de su población es ignorada de manera deliberada. El régimen presenta excusas inaceptables para el atraso en el pago de sus contribuciones financieras, culpando a otros por las consecuencias nefastas de su modelo económico. La Argentina es y ha sido siempre comprensiva ante las dificultades financieras que atraviesan los estados que forman parte de esta Asamblea, pero no puede hacer caso omiso de la realidad de los crímenes del régimen venezolano. Muchas gracias, señora Presidenta.
I thank the delegation of Argentina for their statement, and I give floor to Venezuela. You have the floor.
Gracias, señora presidenta. Buenos días a todas y todos. Siendo también la primera vez que tomo la palabra, me permito felicitarla por su designación como presidenta de esta Asamblea, deseándole éxito en las a todas luces difíciles sesiones que tendremos a partir de esta mañana. Señora presidenta, Venezuela ha tomado nota, con sorpresa sin duda, de la intervención del representante del gobierno de Milei en esta sala, que desafortunadamente confunde la normativa técnica con elementos políticos. Nosotros escuchamos atentamente las distintas intervenciones que se dieron esta mañana en el podio y agradecemos que se haya criticado la politización. Pero, señora presidenta, si había alguna duda de la politización de nuestros trabajos, creo que ha quedado lo suficientemente soliviantada y se demuestra que desafortunadamente estamos conduciendo a esta Corte y a esta Asamblea hacia un rumbo peligroso, ajeno a la normativa que debería sensibilizarnos en el tratamiento de nuestros temas. En primer lugar, señora presidenta, quisiera rogar su indulgencia para evitar que términos peyorativos hacia mi gobierno y hacia sus autoridades legítimas puedan darse en esta sala. Siguiendo el lenguaje de Naciones Unidas, me permito agradecerle a usted tomar los correctivos necesarios para evitar cualquier término que pueda ser improcedente e imprudente, sin lo cual Venezuela se reserva el derecho de hacer tantos puntos de órdenes como sea necesario. En segundo lugar, señora presidenta, quisiera dejar muy claro que Venezuela reconoce las deudas que mantiene con esta organización. No solo las reconoce, sino que por escrito ha dejado manifiestamente claro que está en deseo y voluntad de pagarlas una vez que sean posibles. No es un secreto para nadie que Venezuela sufre más de 900 medidas coercitivas unilaterales de la parte de algunos estados que desafortunadamente han considerado que las sanciones ilegales, crueles y criminales son la mejor forma de atacar a mi gobierno sin menoscabo y sin importarle los derechos humanos de mi población. Eso es algo fáctico, es algo objetivo, es algo que es demostrable, es algo que está contenido en informes de mandatos independientes de Naciones Unidas y sobre esa base, los años anteriores, Venezuela también ha solicitado esa exención que ha sido autorizada por esta Asamblea, incluyendo, por cierto, la representación argentina. De tal manera que nos sorprende, nos entristece, nos preocupa, que esta Asamblea pueda ser conducida por razones políticas hacia una tendencia sancionatoria. En el mismo momento en que las autoridades de la Corte están criticando las sanciones posibles contra ella, se presume que esta Asamblea pueda tener una sanción contra Venezuela. Nos luce desafortunado, nos luce lamentable, nos luce improcedente, y yo hago el mejor llamado a las delegaciones, a usted, señora presidenta, a todos quienes están en el podio, para evitar que una acción como esta pueda ser avanzada, pueda ser eficiente, pueda ser aprobada por una Asamblea que, al contrario, debe trabajar sobre la base del consenso. Señora presidenta, al principio de la intervención argentina, obviamente la sorpresa nos abarca. Yo quiero, sin embargo, dejar constancia que finalmente resulta un beneficio para mi patria, para mi país, que sea un gobierno como el argentino, que recientemente incluso ha criticado decisiones de la Corte y que recientemente incluso se ha manifestado en contra de la eliminación de la violencia contra las mujeres y las niñas en la Asamblea General de Naciones Unidas, quien haga esta solicitud. Creo que un gran favor nos hace para seguir demostrando nuestro férreo compromiso con los derechos humanos. Cuento entonces con que el procedimiento que se actúe y que se active a partir de ahora evite todo régimen sancionatorio y tome en cuenta que Venezuela tiene la voluntad de pagar, pero no puede hacerlo por causas que le son ajenas y que van más allá de su capacidad real, lo cual está demostrado documentalmente. Gracias, señora presidenta.
I thank the delegation Venezuela for their statements. I see Argentina requesting again the floor. I will give the floor. I would suggest to be rather brief so that we would be able to move on our agenda. You have the floor, Argentina.
Gracias, señora presidenta. Seré muy breve. Simplemente para decirle que rechazo en todos sus términos la intervención de Venezuela en cuanto se refiere a políticas o decisiones de mi país. Muchas gracias.
I thank Argentina for a brief statement. I do see a country requesting the floor, but they would have to push the button in order to enter the list of speakers. I will give floor to Canada, and also in their statement asked to be brief so that we can move on. You have the floor.
Thank you. Yes, I will be brief if I'm allowed to have the mic for a moment. In the interest of the good order of the proceedings, I would suggest on behalf of Canada that we call on the Bureau to intensify its work on establishing criteria for the granting of waivers. It might spare us the debate that we are entering into at the moment. Thank you.
Thank you. Thank you, Canada. And with this statement and having heard the statements of Argentina and Venezuela, I would propose that we revert at a later stage to the issue of waivers from the loss of voting rights. Meanwhile, we would consult as appropriate. I would like to stress once again the importance of ensuring that the court is provided with the necessary financial resources. The state of arrears and the liquidity issues facing the court are matters of great concern. I encourage all state parties to transfer their assessed contributions in full and on time in the event of pre-existing arrears immediately, in accordance with Article 115 of the statute and Rule 105.1 of the financial regulations and rules. And I would just like to pause for a few minutes in order to allow the principals to leave the il podium.